Good afternoon, and welcome to the Quarles & Brady Business Law Training Session titled Effectively Handling Internal Investigation. I'm Kim Mahan, a partner in the Business Law Group. Before we begin today's presentation, we would like to invite you to join us in August for our next program on corporate foundations. As always, we have a few housekeeping items to review. For CLE credit, for our in-person guests, please fill out the CLE sheet located at the registration table before you leave today. For our webinar guests, please email the CLE form located at the back of the PDF materials to Megan Blythe, whose contact information is on the form. If you are listening via webinar and have a question, please type your question into the question box on the upper right side of the screen and press send. The conference host will make sure the speaker receives the message. Also, for our webinar participants, we have muted all phone lines and participants are in a listen-only mode. A survey will be emailed to you after the program. Please be aware that this presentation is being recorded. And now I'd like to introduce today's speakers. Ed Broker is a partner in the Business Law Group and is the leader of the International Trade and Supply Chain team and chair of the Indianapolis Business Law Practice Group. Ed regularly speaks on business, corporate, and compliance matters at national and international law conferences and workshops. He is also the chair of the Internal Investigation Subcommittee of the Corporate Compliance Committee of the Business Law section of the ABA. Bernarda Beraldi is the Senior Director, Ethics and Compliance for Cummins, a publicly traded manufacturer of diesel engines. She has 15 years of experience and is a dual licensed attorney, Brazil and Indiana. She was a finalist for the Compliance Officer of the Year, Large Company at International Women in Compliance Awards in 2019, and was the only Brazilian listed in the 2017 Ethisphere's list of attorneys that matter. Anne Fry is the Vice President, General Counsel, Secretary, and Compliance Officer of Vertellus. Vertellus is a specialty chemicals manufacturer with over 900 employees and operations in 4 countries. Through her more than 20-year career with the company, Anne has played a leading role in leadership changes, mergers, international growth, divestitures, and anti-bribery investigations. Susan George is an Assistant General Counsel for Wabash National, a publicly traded manufacturer of transportation equipment. She is a business unit counsel for the commercial trailer products and final products divisions, and she works closely with the General Counsel, leading efforts to update and strengthen the compliance and enterprise risk functions. And now I will turn it over to Ed Broker in Indianapolis. Thank you.
Thanks, Kim. A couple of additional housekeeping matters. We're going to try something that we've never tried before, and that is to have an interactive poll. So you'll see during our presentation a couple of poll questions that pop up, and how you interact is you're going to need to text to Quarles & Brady 02, and you type in 22333 or vice versa. So it's on the instruction sheets on your on the first page of the handout. So with that, we are going to move forward here and give a little overview. We're going to then dive into a hypothetical to tease out some of our topics that are up on the screen. But first, what we should do is to give a little bit deeper introduction of some of the panelists on the up here on the dais, so that we can understand where they're coming from, the size of their companies, and a little bit more about their background in compliance and investigation. So first, I'm going to hand it over to Bernarda Beraldi.
Hi, everybody. Excited to be here with you today. I work for Cummins, as they said in the introduction. It's a diesel manufacturer company that's present in almost 200 countries. We have 62,000 employees, 6 1,000 dealers, 600 distributors, and a little bit more than 60 JVs. Apparently, we like the number 6 very much. And operations, again, in almost 100 countries create a lot of compliance concerns and issues and challenges and opportunities for us. And I'm here to talk a little bit today about how we handle investigations.
Okay. And then Ann.
Thanks, Ed. Ann Fry, General Counsel and Compliance Officer at Vertellis, a specialty chemical manufacturer, which is headquartered in Indianapolis, Indiana. Our roots go back over 100 years, and we're the opposite end of the spectrum size-wise from Cummins. We have about 900 employees, and currently we have operating locations and offices in various parts of the United States, India, China, the UK. We've previously also been present in other European countries as well. And our products, we're privately held, so we don't have SEC issues, which I think, that's going to factor into some of the answers that Susan and Fernanda give and that some of you might have as well. But, we have a lot of the same issues in that we're doing business where there is risk, and we certainly have stakeholders, owners, and lenders and employees who have expectations about how we'll conduct ourselves. So I'm looking forward to sharing a little bit of that as we go through.
Perfect. And Susan?
Good afternoon. I'm Susan George, Assistant General Counsel at Wabash National Corporation. And Wabash National is a leading manufacturer of liquid or transportation equipment and other liquid transportation equipment as well. We have about 8,000 employees, primarily in the U.S., but we do have operations in Mexico and the UK as well. So some of those international considerations. But prior to my current role, which I've been in for 9 months, I also spent 10 years with Smuckers and was responsible for the compliance function there for part of my tenure while I was with Smuckers.
So as you can see, we have a great depth of various companies from small to large to medium-sized companies, both public and private. So it's going to be a very interesting conversation. So let's dive right into our first audience poll, and that is, tell us a little bit about yourself online. So are you part of the legal function? Are you solely in compliance? Do you have a dual role, compliance and legal? Are you part of legal and HR, or are you a Quarles and Brady attorney? Okay. Well, we have at least one success, and that is that the poll works for multiple locations. So very happy about that. And okay, so it's a good mix. So we've got a lot of legal, we've got a good handful of pure compliance people. So this will be a very interesting conversation and discussion. So we're going to move to our first slide on the hypothetical, and that is, and so I'm going to read a few of the background checks here, and then we'll go right into some of the discussions. So Monica Geller is the CEO and Chief Compliance Officer at Monica's Bistro, which is a publicly traded multinational restaurant and frozen meal chain based in New York. Monica's Bistro sells food through its company-owned stores, and it also has a significant global network of franchisees. Following Monica's passion for organizing things, Monica's Bistro recently acquired Byrex GmbH, a publicly listed German manufacturer of glass containers that sells its products through company sales reps and third-party sales agents throughout Eastern Europe and South America. During the integration, Byrex adopted Monica Bistro's compliance policies and procedures, and it also integrated into Monica's ethics helpline. Last week, Monica received an anonymous ethics complaint via voicemail from a bistro employee based in France. The complaint raised concerns about a sales practice of Monica Bistro's sales manager in Paris. The anonymous employee alleged that Gunther, Monica Bistro's sales manager, contracted with a third-party logistics company, Shady Moves, to indirectly pay bribes to government officials in France to get expedited customs clearances to import Monica's delicious dishes. The anonymous employee alleged that she had copies of shipping invoices from Shady Moves for products that were never shipped, and that Monica Bistro's general manager in France, Phoebe Buffet, authorized the payments in an email. The payments were then made through Apple Pay. So Monica decides that an investigation is required and hires a law firm to develop an investigation plan. The law firm must consider who will conduct the investigation. So in your opinion, who should conduct the investigation? HR, outside counsel, in-house counsel, the audit team, or can I call my mom? Okay. So, okay. So the overwhelming majority of the people seem to think that outside counsel should lead the investigation. So Fernando, what do you think?
I guess this is very good news for Quarles and Brady. We would also call, at Cummings, we will also probably call outside counsel in this case. Again, it's a lot of different countries and jurisdictions. You probably need somebody who's very well versed in document collection and evidence collection in France, which is not an easy jurisdiction. A lot of employee protection and data privacy coming from GDPR in that country. So we would probably hire outside counsel. Second, the runner-up is calling my mom because she can find anything.
Anne?
I completely agree. Outside counsel for all the reasons Fernanda raised, and I do frequently call my mom when I'm sick as well. Additionally, you're likely to end up with some employee discipline, or you may end up with some employee discipline besides just the fact that you may have a corruption issue and a reporting issue related to that. And you only have to trip over protections in Europe once to realize, oh boy, you need to have someone local who can help you with that. Like there's nothing like conducting a whole investigation and disciplining the employees, and then all of a sudden realizing all those, as a part of the discipline, you have to hand over to the employee all those files, all those memos that you did. It's good to have that on the front end. So that would be another reason outside counsel. Additionally, of course, privilege, right? To the extent you do want to retain privilege throughout all of this, and you haven't made that first mistake that I've only made once, you're not going to have in-house counsel privilege recognized in most places in Europe.
The one thing I would add is I agree that it should be conducted by outside counsel, but there's no reason that you can't also lean on your internal audit team to give information and to help your outside counsel with the investigation. Internal audit has a wealth of information, and they know the systems and how to get data better than anybody else in the company a lot of the times, and they can kind of do things behind the scenes, and they're very discreet. They're often certified fraud examiners and so forth, so they're really helpful in any investigation that has financial implications or that deals with financial reports and that type of thing. So, and if outside counsel is directing the audit team, for the sake of providing legal advice, that doesn't disrupt the privilege concern.
And so, in when you hire and engage outside counsel, what do you view the relationship with the primary lead in-house person to be? How involved do you want to be in the entire process, Susan?
I want to remain involved if it's something that could significantly impact the company. I know the business better than outside counsel. I know the players, the people, who has the best reputation or who's been around the longest, and I'd like to be a part of that conversation with outside counsel to provide that perspective, and they can provide the expertise in terms of the foreign laws and so forth along the way.
Anne?
Right, very much the same. I treat that engagement of outside counsel just like any engagement of outside counsel, that I, as the in-house legal person, am directing it as much as I'm able to retain the privilege that I'm fighting so hard to get by having outside counsel. If it's a simple investigation, it's going to be so much more just give me a high-level report, go and do it, check in with me about process. But if it's complex, and this is going to be complex, right? It's complex. I'm going to be involved in the planning sessions. I'm going to be okaying the plan of attack. The other thing about, knowing the people they're investigating and where to get the information, but you also know the people that you've got to report up to. And that's really important as well.
And you're probably going to have more requests to provide information internally about what's going on up in the senior leadership than anybody else, right? And you're the one that's calling directly to outside counsel to find out what's going on. Plus, again, and not trying to run away from the reality, the Venn diagram of lawyers and control freaks is pretty, right? There's a lot of gray zone in there. So, I mean, I'll do the same. We'll just be involved. It's a collaborative work, collaborative project, and just making sure I have the information when I need to report internally.
Right. And we've mentioned privilege multiple times already, and I just love this cartoon that we found. And so, in case you can't read it, it's the intricacies of the attorney-client privilege are funny, but not in the ha-ha funny, but in the psych, you're not protected funny.
Yeah.
So I just love that cartoon, because the intricacies of privilege are very unique, and they're counterintuitive in many instances, and in a lot of the jurisdictions, particularly that we've referenced in the hypothetical already, they're not really well recognized. And so, I mean, you just need to ask some of our competitors in Germany. They had a couple of dawn raids into their own law offices at Jones Day or some of the others that were not a very fun day. In
India, there's no privilege for in-house
Right.
attorneys, right?
Exactly.
And there's a hotbed jurisdiction for certain misconduct. So.
Right. So, and just a plug for our annual ethics seminar in November and December, where we will talk a lot about the attorney-client privilege. So be on the lookout, so that when you need your year-end ethics credits, be on the lookout for an email from Quarles and Brady. So we're coming to our next poll, and that is, what attorney-client privilege law should be applicable? Should it be France? Should it be New York? Should it be the law of the applicable outside counsel? A combination of all the above? Or what is privilege?
I guess we did a good job conveying that privilege is something that people should know.
So it looks like France is clearly the choice du jour. What do you think, Ann?
Well, again, that's why I'm going to hire my outside counsel. sort through that, Ed. But I think they're all going to come into play, right? Yeah. They're all going to have an impact, and likely, as you dig into this investigation further, another jurisdiction or an employee located somewhere else is going to come into play, and there's going to be yet another jurisdiction. Right?
Yeah, I would say the same. The combination of the above. I mean, as for us that have been involved in investigation before, not at Cummings, but in my prior role, you know that's a snowball. They're going to ask you about one jurisdiction, and then another jurisdiction, and then another jurisdiction. So France is the flavor du jour, but it's going to be a combination of the above. Right. Yeah.
Yes, it sort of depends where you end up having to claim privilege. Like, wherever there is an authority that you need to disclose to, or if there's a lawsuit, or then that's where you're going to have to start looking at.
Exactly. So, all right. So then, continuing on with our hypothetical, we now get into Monica informs the law firm that Monica's Bistro maintains electronic documents on a central server in Germany. So Monica asked the law firm to then consider the collection and review of electronic documents on the Bistro's central server in Germany and other documents in Paris, the challenges posed by WhatsApp, Telegram, and similar electronic messaging systems that are not controlled by Monica's Bistro. Same issue with relationship to the e-payments, because recall that the sales manager paid with Apple Pay. And then who should conduct the interviews, where and how. So with that, let's, do you have any comments about that, Fernanda? I know you're deep into.
I have so many comments. I will get started with the whole WhatsApp, Telegram, what the DOJ is now calling ephemeral messaging, with like a blanket to refer to all those apps. Companies out there, and Cummings included, there's a need to have a policy that tells your employees what they can use those apps for and how they retain information, right? If you remember 15 months ago, the DOJ said it's prohibited, the use of those apps is prohibited. Now they kind of walked that back after the Chamber of Commerce. There was some kind of pressure coming from the Chamber of Commerce saying that, well, you can't really say you cannot use those apps. And DOJ understood that, and they walked it back and said, okay, but you have to have a policy in place. So companies out there, please revisit the use of apps by your employees if they use their personal phones for business, think about that. Or if they use their company phones for business, think about that. Put a policy in place that allows them to do something or nothing, but say something about it. Have a policy and implement the policy in a way that when the DOJ comes knocking on the door, and please notice I'm saying when, not if, you'll have something to tell them, right?
Susan?
I agree that the policy is important, and this is, I mean, even outside of apps, if you think about just basic instant messaging, are you going to retain those records, or you're not going to retain those records? And it's fine either way, but you do need to have a policy and then kind of follow it. And if you decide to say that instant messaging, that type of thing is more of that kind of informal, it's a voicemail correspondence type thing or whatever, and it's not a business record and we're not going to retain them, then okay, then they're not discoverable, then they're, you're not going to use them as a business record. But it's just important to be clear about that.
And I would say it's also important to be realistic, right? The knee-jerk reaction in the early days of these tools was just to say, as a company, you can't use it. Our employees can't use it. You know, and you know, then you might, I don't know, go visit India and realize that you've got 100 people there, and they try to use the systems, but they're really slow because of, infrastructure issues, and they all have WhatsApp, and and that's how they're communicating with everyone. And it's the combination of social communication with their colleagues, but there's also work-related stuff. They're confirming meetings with customers. They're checking in with their boss. They're sending pictures of their babies. It's everything under the sun. So the reality is, your people are going to use these. I think that's the other thing about it's not if, it's when. They are going to use them, and so you just need to have a pragmatic policy to deal with it.
If you're a company that has operations in China, people live based on WeChat. Right. Our own company has a corporate account on WeChat, and we post to our employees on WeChat. So just curbing the use of the apps altogether is not going to work. You just have to create the rule around what you can and cannot use them for.
That being said, and I guess I don't even know the answer to this, but I would think that in some circumstances, you wouldn't have the ability to get access to your employees' records on these apps anyway, even if you told them that, it's a BYOD, so if you're conducting company business, we can search your text messages. If they don't turn that phone over to you, then you'd have to try to subpoena it, and, would the phone company actually turn over those text messages to you? Probably not. They don't care what your policy says. And
in certain jurisdictions, this is going to be even harder, right? Thinking about GDPR, et cetera, in France and Germany.
Well, China, too.
China,
Right. But the worst thing is, it's worse to have a policy and not follow it than not to have a policy. So while we're all about creating policies, it has to be, as Ann said, it has to be a pragmatic policy that you can live with and you can justify and defend. Because if you can't follow your own policy, it's going to be a lot worse. The cover-up's always worse than the crime, and not always. I mean, in most instances, the cover-up is worse than the crime.
Or at least it's the thing that gets you caught.
Exactly. So one element of privilege, and we can kind of go back to that, is Upjohn. So Susan, do you want to talk a little bit about what Upjohn is?
Sure. So Upjohn is a mechanism to allow you to attach privilege in an investigation. And what it's intended to do is to make clear to the person that you're interviewing that you are an attorney for the company and not for that individual, that you represent the company, and that you're conducting this investigation or doing this interview for the purpose of providing legal advice to the company. And therefore, they have to keep it confidential, but it's, but you do, it's your privilege, it's not theirs. In other words, you, the interviewing attorney, do not have to keep it confidential. It's your privilege to waive if you choose to do so. So it is something that you're supposed to provide when you sit down with the witness. If you're trying to protect the conversation, under attorney-client privilege, there's, kind of 4 statements that you make to them saying, I am an attorney for the company. I am doing this investigation to provide legal advice, and you can't share it. It's the company's privilege that we're protecting.
And so Ann, since you're the general counsel and the chief compliance officer, how does that work in the C-suite when you have to investigate one of your colleagues up in the C-suite? How do you explain to them? Oh no, this is a company privilege, not yours.
Well, right. It's interesting because there's an interesting reaction from almost anyone you give an Upjohn warning to, right? But it's different, right? Especially the C-suite folks, because they view, and they are in many ways, they are the company. Like, okay, yes, you represent the company. I am the company. Like, well, not in this instance. You are not the company. And in fact, it will be, the audit committee of the company or the special committee or the CEO, if I'm not talking to the CEO, who makes the decision about privilege and waiver of privilege, and not you, even though you're normally the one who follows that. So it's interesting. It's an interesting conversation, no matter who you have it with.
Exactly. Fernanda?
Well, if I give an Upjohn warning outside the U.S., people will look at me and say, I thought you were my friend. And again, the understanding of the need for Upjohn warning outside the U.S. is not the same as within the U.S. Sometimes you don't even have to give an Upjohn warning outside the U.S. to have the privilege attached. In some other countries, you won't have the privilege attached anyway, right? So my biggest concern, if you have to give Upjohn warning to anybody, is make sure people understand what this is about, right? Inside the U.S., outside the U.S., because again, for them, you're just 2 days ago, the business lawyer, you maybe just the business lawyer helping them to get stuff done, right? And suddenly now I need to interview you and you need to tell me everything. And by the way, it's confidential, you cannot tell anybody, and I'm not your attorney, right? So it's the way of delivering that message across cultures could be a little difficult.
So, it looks like a lot of people suggested to give it to everybody, but that might be the easiest and path of least resistance. But as Fernanda indicated, you may be overbroad in terms of the need to give it to everyone, and it may raise more confusion than be beneficial. So,
just to add to that, I would say that I would work with my outside counsel, and if there's not even a chance of privilege attaching, I would never give it. And if it's not, even if privilege could attach somewhere outside of India, without giving it, I wouldn't give it. Right. It's just culturally, it's too hard to translate.
Exactly.
It shuts people down.
It shuts people down. Yeah.
And then you're not going to serve what your company needs to get to the facts.
Yeah. The number one question that you hear, and I heard that myself, giving an Upjohn warning that I didn't want to give, was, do I need my own attorney? And then what happens? Then the person does not want to talk to you anymore, right? So that's why I say it needs to be, if we're going in the blanket statement, everybody will do as most of the people are preferring. I would say just be cautious when you do it.
Right.
Yeah, and we talk a lot about privilege, but I would say rarely is that the highest priority when you're doing an investigation to maintain privilege. You actually are trying to figure out the facts of what happened and fix it.
Yeah.
And privilege is kind of a secondary.
Yeah. And we all know, when we read DPAs, DPAs and MPAs, when DOJ and SEC, they're saying, this company collaborated. What they're saying is they waived a bunch of privilege, right, to get to the documents they needed to get, right? So, yes, we want to protect it. We'll try, but bottom line is you may have to waive some of them.
Right. Okay, so continuing on with our hypothetical. So yesterday, Monica received an anonymous email ethics complaint from Byrex employee located in Russia, raising concerns about the sales practices of Byrex third-party sales agents in China. The anonymous employee alleged that Rachel Green, a third-party sales agent, was giving Ralph Lauren Couture clothing to government purchasing agents to win the Chinese government bids for frozen foods, increasing the demand for Monica Bistro's brand new products. Finally, the anonymous employee threatened to go to the anti-corruption authorities in China and Russia if Monica Bistro did not investigate Rachel. The employees also said that he expected to be protected under the whistleblower protection laws, despite not saying his or her name. So Monica asked the law firm to expand the investigation to Russia and China. The law firm then considers the collection and review of the documents located in China and Russia, including the differences from the data privacy laws in the EU, whether documents can and should be transferred outside those countries for the document review, whether the interview should be conducted by foreign counsel or local counsel, and whether Monica's Bistro should consider self-disclosure in light of the potential whistleblower. And if so, who should she disclose to? So, Fernanda, let's take the first question. The collection and review of documents located in China and Russia and the differences between the data privacy laws throughout the EU.
Yeah, you will, this hypothetical, you will have a hard time taking those documents out of China and Russia. And when you are imaging those computers from the employees, you will also have to do probably locally by a person who speaks the language and explains to the employee what's happening. The imaging of the computers will probably have to be reviewed by somebody local, not only for language purposes, but because, again, of the data protection laws in Russia and China. So, again, you're just thinking about the cost you're adding, the Quarles and Brady people getting millionaires, becoming millionaires. You have to do that. The cost you're adding to be able to have a document collection and respecting data privacy, it has increased substantially after the passage of those new data privacy laws. So that would be my route.
Right. Anne?
Still on the first question?
Yeah. Well, the first two are intertwined.
Yeah, right. I think, again, I agree. You are unlikely to get those documents out. And you are also likely in this process to realize that maybe your internal process about where your stuff across your global company is on a server somewhere might be problematic under the laws where your employees are located. Right. Yeah. So you might have some other things that you decide you're going to fix along the way as well. And again, it's going to be expensive. Not to say you shouldn't investigate, but it is the importance of scoping at the beginning and continually checking the scope that you've set, and don't let it get too big too fast, because you're going to have a huge expense otherwise. So it may not be justified.
Yeah, I mean, I think, Susan, I mean, the whole scope creep is what is I hear all the time from our clients that, you know, look, I want you to limit it here, and we keep wanting to expand it a little bit, and they're like, is that really necessary? Are you going overboard, or is that something that you really need to go with? So,
absolutely. I mean, it has to be a continuous conversation, and there is a tendency to say, oh, new information, let's chase that, let's chase this, let's chase it in all directions, and you can't do that because, you know, at some point it's just not worth it anymore.
But I mean, at least after GDPR, you now know where most of your records are located. So you've mapped them out. And with California coming on board in January, you're going to have a similar mapping exercise, at least for the most part in the United States. So you'll at least know where most of your records are located, and you can maybe make Anne's job a little bit easier in terms of, is that really the right jurisdiction for this type of record, so that if this issue arises, we may want to revisit whether we host everything in Germany or Russia or wherever. So should the interviews be conducted by foreign counsel or local counsel? Anne?
Well, the first issue in my mind there always is the language, right? It's even more important than privilege, because, to Susan's earlier point, what we're trying to do is learn the facts and determine the appropriate corrective action as quickly as possible. And going in and conducting an interview that has to be translated, it's a recipe for failure. As much as I am a control freak and want to be in the room and I have lots of good translators, I've learned that is not effective. So, and even if I have even if Ed's coordinating this globally for me, if we're in, a certain country where my employees don't speak English well, or or it's simply not their first language, even if they do speak English well. I'm going to insist, Ed, that you have local counsel who's good, who understands working for a multinational.
Right.
That's a whole other issue.
Mm-hmm.
But can actually speak in the language there, and no translation going on during the interview.
And dialect as well.
Oh, yeah.
In many instances.
Yeah, India. How many languages in India?
Oh.
You know, like 40 or something like that.
I agree.
I want to address the whistleblower question that you have here.
Yeah.
I mean, there are a lot of firms out there, different than Crohn's and Brady, that are out there in countries like India and China, just educating employees that may have seen potential violation to bring a whistleblower claim, right? Sometimes directly to the DOJ or directly to the SEC if the companies are listed, right? So it's important that in this case, speak up culture, that you have a culture that's firm and an ethics helpline and an investigation process before this issue becomes a real issue. So employees can try to go through that route, but do not forget that there are people out there whose only job is to try to get a whistleblower claim against the company. And if you have that, it's a complicated issue to deal with, right? Especially in this case, which is anonymous, right? Like, I want to be protected, but you're not telling me who you are. A little bit complicated.
Yes.
Yeah, and I mean, the interesting thing here is this whistleblower is threatening to go to the authorities, even though, you know, Monica hasn't had a chance to respond and to say that, you know, the company was going to take action and fix it to begin with. But I would question in this instance if they would get the appropriate credit for voluntary disclosure if they're only doing it because there was a whistleblower. That's not really voluntary disclosure anymore. And that's a big piece of the reduced penalties under the federal sentencing guidelines, is that it has to be voluntary and the cooperation and so forth. And I don't know if you'd qualify in this instance.
Yeah. Once you have the internal, once there's that little beautiful thing in your email, it does not become voluntary anymore, right?
So let's take an audience poll. So would you advise disclosure at this moment in time? Yes, no, or Alex, can I choose places where I wear orange jumpsuit for 300 million? Interesting, okay. Good. I'm relieved because when that yes jumped up first, I was like, woo. But yeah, I think no in this instance is probably the right answer, just because we don't have a good handle yet on the facts. Fernanda, you agree or?
Yeah, I at this moment you don't have a good handle on the facts, and I much rather have a better view of what's going on and say we found out this. We did this and we remediate this and then go. But again, the decision to disclose is very, very complicated. It's in no set of 4 people here in this room without knowing the facts can tell you, yes, you need to disclose, or no, you don't need to disclose. If your company is going to be, you know, publicly listed within 3 months, then it's a different, right? If you're going through another type of investigation with the DOJ, then it's another consideration. So it's a multi-factor consideration that cannot be taken alone. You cannot isolate that decision outside the context of what's going to happen with your company, what happened with your company in the past, and what is happening with your company. So that will be my view.
Well said.
Okay, so assuming that we did want to disclose, who would we disclose to? DOJ, SEC, France, Germany, China, and Russia? Just the U.S., France, China, and Russia? France, Germany, China, and Russia? Or I wouldn't disclose. So yeah, kind of beat ourselves to the punch on that one. Sorry. So we'll let people keep typing in. And I forgot to mention at the very beginning, if any of the offices have questions or thoughts, feel free to chime in and we can take it, because interaction is always better. So, okay, so now we get into a bribery complaint in Russia and China. So while the law firm was implementing this document hold and collecting all the electronic records, Chandler Bing, Monica Bistro's China CEO, receives a notification that the Chinese anti-corruption authorities have arrived in our Beijing offices to conduct a dawn raid based on the whistleblower's allegations. So what should the law firm do in response to the dawn raid? Does the dawn raid trigger mandatory reporting disclosure requirements? And, well,
Yeah,
yeah,
right there.
sorry. Yeah, so what should, so while the law firm was continuing to implement, Ross Geller, Monica's chairman of the board, invites Monica for a meeting, and in the meeting, he brings up that the audit committee members with him. The audit committee members inform Monica that given all these issues in the investigations, they want to get paid more money, double their current stipend, as the audit committee members. So what should Monica do? So let's take the dawn raid question first. So Susan, what do you do in response to the dawn raid?
This is one that is like something that I've never encountered before, so I would be listening to my outside counsel 100% on that issue.
Okay.
I don't know if Fernanda has had specific experience.
Yeah.
Sadly, I have had a predecessor company, you gotta say. And the reality is, you can't do anything, right? The dawn raid happens, right? And so it's a good thing if you've trained your office head in jurisdictions where dawn raids can happen. If you've trained them in advance that, it's good to have a general policy about what happens if you get a subpoena, if the government shows up at the door, whatever, but including dawn raids. And the bottom line is, when they come in, you step aside, they do what they do, you do what you can to pay attention to what they're taking, what they're doing. You want to have hopefully given your team guidance in advance about whether they are required to answer questions or whether they simply step aside. It's terrific if you have local counsel on call, maybe this local counsel is already there, who can also be there and make sure your people do what they need to do, but nothing more than what they need to do. But the bottom line is, it's the middle of the night or wherever you are, and someone's just woken you up with a phone call, and all you can do is hope that you refer them to the policy. If you've done it, refer them to the training, and try to get local counsel on the ground. And if you can't, you tell your people, respond to instructions, pay attention to what happens, and call me as soon as it's over, and we'll go from there.
Take a copy of the warrant.
Yeah, yes. Hopefully that's in your policy.
Yeah, I mean, as Ann mentioned, it is going to happen, and the best thing that you can do is be professional and cooperate, but don't volunteer. Don't say, oh, you should look over here, or this is where we really keep the good records. No, it's you need to delegate to somebody in charge, and then have that person be the conduit with the authorities, and to make sure that they professionally and appropriately respond to questions, but don't volunteer and don't try to get uppity or antagonistic, because it's never a good thing.
Yeah, I would say the same. And first of all, try to get your counsel there as quickly as you can if you have a local counsel. Very important, as Ann said, hopefully you have a policy in place where you train all the heads of the offices and the people in the front desk really how to deal with this, because sometimes they get that.
You have people at front desk?
Some people get desperate, right? They don't know, right, what to do. So train them to make sure they know what to do. Get your counsel there. Your head of security in each office, if you have one, they're usually a former law enforcement, so they speak the same language, so it's more helpful. Does that make it sound like I had experience with that? It was a prior company, but I did. So, yeah, and make sure you have a copy of the warrant, right? And don't let them like wander around your facility without being with somebody. You're not there to interfere, but it's important that they have somebody with them. That would be.
And to the extent that you can document what they're taking, they obviously have to inventory what they're taking, and they'll provide it eventually. Yeah. But if you can have an idea on the front end what they've taken, that will be very helpful.
Yeah, I guess I know we have limited time, but my one dawn rate experience was in the era of mostly paper files,
Yeah.
not so much digital files. So it must be interesting today when that happens, to the differences that arise and the access that they might get.
Yeah.
They just yank stuff out. I mean, they
Take the hardware.
They take it. Yeah.
They do.
Okay.
Yeah. Especially when like you have like a server room
Mm-hmm.
and you don't know exactly where things are in the server. So the concern is, yes, they're here to collect evidence. We want to help, but you can't shut down the company by taking the entire server, right? So we can help you collect the data you need if you tell me what data you're looking for, because you can't really shut down the company for days by taking the entire server, right?
So does the dawn raid trigger reporting and disclosure obligations?
It's not going to be voluntary anymore. Yeah, and I mean, this is Twitter world and Facebook world. It's not going to be contained to whatever location this happened. It's going to be all over the news. Next day, next 2 hours, next hour, or your own employees inside the company tweeting, oh my God, the FBI is here. That's not novel. That has happened before. So once you have that, then you probably have to, collect the things you need to collect and start thinking about reporting.
Yeah, have a crisis management communications plan.
Yes, that would be really good too.
Yes, a holding statement from your PR.
Yeah.
Exactly.
Yes. So, and you mentioned the social media from your employees. I mean, you obviously can't prohibit that, but it is very important to counsel them in terms of, the implications or the potential implications that their tweets and their posts on Facebook and other places may have. And so, obviously you can't quash their speech rights, but, messaging is very important and, just as in everything. So, so going back to the next question about the audit committee wanting twice their normal stipend. Susan, what do you think about that?
Well, they're asking the wrong person. They should be asking Monica. They should be referring that question to their compensation committee, I suppose, because the board is typically going to determine their own compensation through the compensation committee. And it might be that they warrant additional compensation just based on the complexity of the company and everything that's going on and the additional work that they'll have to do. But they would need to work with their outside compensation consultants and, get that benchmarking and get a recommendation and make sure it's in line with what a compensation consultant would recommend given their efforts and everything. And then if it's, if what they want is within the bounds of that report, then the compensation committee can change the compensation structure for the board and go from there.
Yeah, I would suggest that as the compensation committee is working through that, the chairman of the board would refer it to the compensation committee for that. The general counsel, who probably has a seat at that table, might also just point out that optics matter as well, and factor that in as stay within the parameters of what's appropriate compensation. You're going, it's appropriate business. It's going to be an exercise of business judgment that people need to be compensated for work they're doing. Clearly, they're going to be doing more work. But the optics are very poor.
Right.
Yeah, and you have to worry about. The result can be. Shareholders are already. If you're a publicly traded company, your shareholders are already upset because you're all over the news for these corruption issues and so forth. They're probably not happy with the governance of the organization at all, but you give the board a raise and that board's not going to get reelected, the next time that a vote comes up.
Well, and Fernando, I'll go to you next, but this is a real example from last month. So Walmart's lead director, in light of all of their issues in Mexico and elsewhere, did ask for, I don't think it was double, but I think it was 1.5 or a significant material amount of additional compensation in light of the obviously additional amount of time that he's been spending or she's been spending in dealing with the thing. So it is a real issue. And now that it happened to Walmart, I'm sure other directors will be talking to each other about saying, if you got a thorny issue, you may want to see what you can do.
Yeah, and Walmart agreed to pay, and the news came last month, but they agreed to pay before.
Right.
So that was just more like, I mean, informing you that we're paying more audit committee members. I mean, again, Walmart's the largest company in the world. They're paying $900 million just to investigate so far. It's not even defined yet. So you may imagine the audit committee members are very busy, and I mean, they think it's fair to compensate, to get more compensation for it. The company agreed to pay for it. Their compensation committee agreed to pay for it. The point is, what message does this send to the market, right?
Yeah,
Which is,
I mean, that being said, they are subjecting themselves to more risk. I mean,
Yeah.
there is individual liability for board members,
Yeah.
and they could be, you know, accused of criminal conduct and put on trial and so forth. So
Yeah.
putting themselves out there like that,
Yeah.
continuing to serve on that board,
yeah,
perhaps they are warranted additional compensation.
yeah,
Well, and as everybody said, I mean, it is the optics and it's the timing. And so I think Walmart, you know, by doing it quietly at the time and then having to disclose it in the annual report, probably did it as best as they could. But you know, it'd be probably even better if the investigation were closed and the resolution were final before they announced that they also paid their audit committee members what they paid them.
yeah.
So with that, there's one parting for the compliance people in the room. I'm sure you can appreciate this, and we will open for questions if anybody has them or final thoughts. Any questions?
How much time do we have left?
We have about 5 minutes.
Okay.
So, any questions? I can't see the other offices very well. So, Ann, do you have any parting thoughts in terms of should HR conduct the investigation, or what were they thinking?
Well, you know, when I was reading through your deck, I laughed all the way through because, of course, I loved Friends, and I haven't thought about it for a while. But I got to this last slide, and I you know, practically fell over laughing because I'm sure all of us have experienced this, and actually HR even reports stuff into me, and I've experienced this. And, you know, HR folks are terrific. They are well trained to investigate. I tap them frequently to be investigators on compliance investigations. But you know, they've got to be through the correct function. And it's actually a tough call, right? Because HR, they're on the front lines. They're dealing with things every day. And what this really reminds you of, and this is a whole other topic we could spend half an hour talking about, is the importance of making sure you have a good relationship with your HR group and that they understand what to elevate to legal, compliance, whatever, when, so they don't miss a beat in dealing with whatever is the frontline issue that they're trying to deal with, but also getting it to the right place if it also needs to be somewhere else.
Yeah, I mean, I think HR can be enormously helpful when you're thinking about how to approach an investigation. I mean, if you get a hotline report and it says an individual's name that you've never spoken to or encountered and know nothing about, to go and consult with your HR folks. They usually know a lot about everybody, you know, for one reason or another. There's been performance issues, or this person's interested in this different type of role, or there was a romantic relationship with this person and somebody, you know, they have just a lot of that knowledge about that interaction among people within the organization. And that can provide really good context as you're leading into your investigation.
Yeah, and the majority of the cases for companies, the benchmark shows they're not compliant themselves. Like the things that come through the hotline are usually, you know, harassment and other things that are more HR related than compliance related. So as Ann said, those folks are already trained to do certain things. They're a partner of the compliance function, a partner, of course, of the legal function. So, but again, it's just train them in what to escalate to compliance or what to talk to compliance or legal, instead of just saying we can fix everything.
And I think we've now mentioned it 3 or 4 times, and that is to be thoughtful and proactive and have a plan in place. So one of the initial slides talked about forming an investigation work plan. So so to avoid the scope creep, or to minimize it, or at least know that this is the initial focus, and if we deviate, then we need to go back and talk to Ann or Susan. And so to have plans and procedures in place up front, if you can do it, and be thoughtful and proactive about what sort of issues, because you know your businesses, you know where the potential issues may arise. And so to have an idea, you may not always have a dawn raid, but if you have a policy and procedure in place that says if this happens, or you should have a crisis management plan as well, so that everybody suffers from natural disasters. And so if there is a tornado and the west half of the factory blows off, what do we do? Who do we call? And how do we notify our employees not to show up that day? So again, I think the key takeaway from this is to be proactive, have policies and procedures up front and a plan in place up front, so that when the inevitable phone call happens and it's 2 o'clock in the morning and you're groggy and half asleep, you can at least have something to refer to that will at least get you started before you get your first cup of coffee.
Yeah.
Fernanda, any parting thoughts?
No, it's usually compliance and legal folks are in the front and center on any investigation. So as the pilot of the investigation, stay cool and collected, because if you're flying a plane and the captain's desperate, you're probably going to be very desperate, right? So this happens to the best of us, to most of us. So just in practice makes perfect. So run, have policies, have procedures, implement them, run tabletop exercises. So when it's ready, when it happens, you're ready.
In addition, build relationships with experienced outside counsel that you can call at the drop of a hat and say, hey, I have this issue, I'm struggling with it, what do you think? And, even if they insist on sending you a bill for that time, that's fine, because you got your money's worth for that. And also network with folks that are, folks like other compliance professionals, other in-house legal professionals. There are lots and lots of resources out there, formal and informal networking, and that's where you get some of the best advice. Is the true practical advice that you maybe even are at a session with Chatham House Rules, and you learn a lot even in that. So that's, stay out there, stay involved in compliance and legal groups, so you can get experience through others and not necessarily your own school of hard knocks.
Susan?
I don't have any other parting thoughts other than to say, if you have questions that you haven't asked, or that that you wanted to ask privately, I think you have all of our contact information, and feel free to reach out.
Yeah.
Anytime.
With that, Kim, do we need any closing thoughts, or are we done? We're good. All right. Thank you. And next August, we're having our next BLT. Thank you.